Hello and welcome to the Government Contracts Industry Report from FedNexus Law. I'm Jennifer Allbell. Here with me in the studio today is Eric Crusius, a partner at FedNexus, as well as Jim Phillips. Welcome, guys.
Hey, Jennifer.
Hello.
We've got a lot to talk about today, but first I wanted to give Eric an opportunity to recap what he talked about this weekend on Fox and Friends. So, Eric, you had an opportunity to debate with the former White House CIO about the new Apple iOS 8 system. Can you tell us a little bit about that?
Yeah, it's an interesting issue that's come up with the new operating system where Apple has encrypted or allowed automatic encryption once somebody uses a passcode for their iOS system. And that makes it a lot more difficult for law enforcement and other government entities to essentially snoop in and figure out what's on your phone, even with a valid search warrant. So a lot in the government, including the FBI director, were complaining about that. So we had a nice little lively debate on Fox and Friends yesterday to discuss that, and it'll be interesting to see how this shakes out. But this is not the first time something like this has happened, and in fact, Google's Android system is going to do much the same thing when it's released in October.
Thanks, Eric, and I'm sure we'll be talking more about this important issue in future broadcasts. Next, we wanted to talk about a couple of big stories that hit the government contracts newswire this past week. First was word that a federal grand jury had handed down indictments on 5 counts of fraud for former GSA Regional Commissioner Jeffrey Neely. These indictments mark the latest chapter in the ongoing saga related to the infamous GSA Public Building Service Western Regions Conference that took place in Las Vegas in 2010. In another story sure to be generating headlines for years to come, the Veterans Administration's Office of Inspector General released an 82-page report last week, full of stories of fraud, waste, abuse, character assassination, conflicts of interest, and more, in relation to the Veteran Health Administration's contract with FedBid. Although the Department of Justice declined to take criminal action in this matter, it has been referred for administrative action, and we should be hearing more about this soon. So next we're going to talk to Jim Phillips about his blog this week, which talks a lot about GSA's new pricing evaluation process. Jim, you had a lot of interesting thoughts and probably a little bit of controversial information on the new GSA pricing policies. What can you tell us about your blog this week?
Well, I mean, this is a topic, if you read some past blogs we've been noting that GSA has really introduced a whole new paradigm for determining what is a fair and reasonable price on schedule. And I thought it would be interesting to just compare what they're doing with what the FAR indicates is the preferred way of doing price reasonableness evaluation. And my conclusion is that while well motivated, the GSA policy really would benefit from further elaboration, if not explanation, about conforming to FAR-based standards.
So in what ways do you find that the new GSA pricing tools may be in contravention of the FAR and the GSAR?
Well, so the first thing I would say is GSA's pricing policies are embedded only in their solicitations now. And those of you that are in federal contracting know we derive policy and direction from the FAR and then implementing regulations like the GSAR. So in enunciating the new policies, GSA has not gone back and revised the GSAR. They have simply said, in the future, when you submit a proposal, we reserve the right to basically reject a price offer if we determine it's not fair and reasonable based on third-party pricing metrics, either prices we found on other contracts or even prices we found on third-party websites. They use a service called XSB. Some of them use Google. And if lower prices show up there, that would indicate to us that your price needs to be lower before it comes on schedule.
And one of the things that you mentioned in your blog that's really important is that when they're doing this research, they're probably not taking into account any differences in terms and conditions between, somebody selling something on Amazon.com who doesn't have to apply Trade Agreements Act compliance to their pricing. So is that something that you think has fallen by the wayside in the pricing analysis?
Right. That's exactly right. GSA's job is to try to get the best price for the government customer. I don't think anybody should complain about that. And I do think it behooves vendors to do this own analysis on their own to make sure that they're competitive. What I'm concerned about, and what I write about extensively in the blog, is the fact that just finding a price somewhere, either on another contract, on a published website, doesn't tell you everything you need to know to determine if that price that was offered was fair and reasonable in the current context. And I'll just read to you what FAR 15404B2 says. When comparing current proposed pricing to historical prices paid, the prior price must, not may, must be adjusted to account for materially differing terms and conditions, quantities, and market and economic factors. So my thesis is we're not doing that today. My concern is we're just finding a price and saying, oh, there's a lower price, therefore you need to match that price. And we're getting away from what the FAR is telling us, which is make sure that other price you're comparing it to really is relevant because the circumstances, terms, and conditions were the same or similar.
So one of the things I've heard from contractors who call us to ask for advice or talk about these issues is that in some cases the contracting officers are refusing to tell them where the pricing information came from. What recommendations do you have for contractors who are being held to a standard and have no idea where the pricing came from?
Well, first, I think there's two scenarios this comes up with. The one that I really don't have a problem with is if the GSA contracting officer says, look, there's somebody already on this schedule, this SIN with a lower price, there it is for you to see in GSA Advantage. That's a pretty good indication to the vendor that they may, that it might be a good idea for them to lower their price for that item.
Right.
And I have no problem with the government saying, why don't you explain why that price we already have on this contract isn't the appropriate price you should be compared to. So there, the burden switches then to the vendor to really explain why that other price isn't fair and reasonable, because we know the terms and conditions are in fact identical. Mm-hmm. It's the FSS solicitation terms and conditions. The second situation is where the government finds a price outside the schedules. Google, XSB, other contracts. And my advice to vendors would be to say, you know what, we shouldn't even be talking about that price unless we know what the circumstances were. And I'll just give you one obvious discriminator that needs to be taken into consideration. Trade Agreements Act compliance. Items on schedule are required to be compliant with the TAA. The vendor has to certify compliance. They actually have to provide information on country of origin. Unless the government can validate that the transaction and the price that they're comparing you to was also under a TAA compliant transaction, they're not comparable, and it's not relevant to even consider that price.
As an attorney, you make a rather shocking statement that you don't think companies should start filing bid protests about this. But what do you think contractors need to start doing in order to better handle this new pricing guidance?
Well, like everything in GSA, you end up starting dealing with a contracting specialist who has just a ton of paperwork, a ton of transactions they're trying to get through. My advice is always the same. Try to work with that contracting specialist. Be respectful. Support your position. If you get a response that, no, we don't agree with you, you escalate it up the chain of command. And knock on wood, so far in our experience, you can find a more seasoned veteran manager up the chain of command that will look at the circumstances and say, yes, you're right. And that will allow you to be successful. May take time, but it's almost always effective in our view. And of course, you're not incurring legal fees and you're not creating other issues by filing protests.
Well, thank you for your insight today, Jim. And to read more on Jim's blog, including all his extensive FAR citations, check out FedNexus Insight. Well, that'll do it for this week's broadcast. Thank you for joining us for the Government Contracts Industry Report. I'm Jennifer Aubel, and we'll see you next week.